Breakout session on government access to private sector data. Let me introduce myself. I'm one of the two European data protection supervisors. Perhaps in the course of the debate we will have opportunities to see the new European legal framework, not only with regard to our subject, but I would like to immediately exercise my duty to present the topic and then the participants. In this perspective, we all know that government access to personal data and also to private sector databases is not a recent issue. But perhaps we can say that the development of data networks and new technologies has given it a sort of an added urgency. It's not so simple to deal with this issue because this is a vast subject, and it's a subject which is not only of relevance to individual countries or public bodies, but has now acquired sort of a global significance. So globalization is one of the elements we should, in my perspective, consider today. Globalization has transformed the work of law enforcement bodies first, extending it beyond their traditional domestic dimension, and it has made it possible to gain systematic online access to private databases in many countries. Let me just refer to the PNR and to the well-known questions related to air transports. And globalization is also relevant because this online access is now facilitated either directly or through a public authority in another country. So globalization has opened the way to international agreements for the organized exchange of private sector information between law enforcement bodies. Perhaps in the course of the debate we will have an opportunity to make an update to the ongoing discussions in place about the EU-USA principles for a future exchange of data, perhaps including also information coming from the private sector. But globalization is not the only element to consider today. Perhaps we should also have a look to centralization and to the virtual location of databases. Indeed, information within companies is increasingly centralized for operational reasons or economies of scale, and cloud computing too is developing. So perhaps most databases have now lost their earlier physical properties and relatively static location. So just an example, determining which law is now applicable to this data processing and defining workable and effective guarantees, to mention only two aspects, is now far less straightforward. So this is why I propose we deal today with the topic as a global phenomenon, not ignoring interesting national experiences, but focusing primarily on online access and on unknowns and probable trends that await us in the next future. Which public bodies are involved in this subject? All of them, both at the central and local level, in the welfare, education, tax sectors. But obviously, the subject becomes clearly far more sensitive where police organizations, judicial authorities, intelligence bodies are involved. Problems of this type are particularly serious in some countries that are or have been under a totalitarian regime. This has been highlighted, for instance, by the European Court of Human Rights in several cases, which are related to illegal, undisclosed, or improper collection of information on unsuspecting citizens without appropriate safeguards and even after the event. For several years after the 11th of September, there has been a great debate on the disproportionate nature of certain emergency measures introduced in response to terrorism and international organized crime. But ignoring for a moment today the emergency situation that we hope to put behind us, the phenomenon of access to private databases is in any case increasing constantly in all modern democracies. Why? The ready availability of information creates new and ongoing appetites, even to the extent of legally obliging private organizations to create databases that are not necessary solely to manage their relations with their users and customers. So we are speaking about databases created purely to respond just in case to future requests from law enforcement bodies. Leaving aside data freezing, which can be in certain cases justified, let us look, for instance, at the data retention applied to telephone and data transmission traffic, which has now become mandatory for long periods, a matter of normal practice, and not merely as an emergency measure. It is introduced to combat serious offenses, but not necessarily terrorism and serious organized crime. And I will be curious to see what will happen next year about the European Data Retention Directive, since you know there is a sort of a sunset clause, and it will be an opportunity to have a reflection on that. So this is why I propose to discuss today how modern democracies can deal with this issue in normal circumstances. Because those operating in such democracies frequently go beyond what are the reasonable bounds of proportionality and security in the collection and use of information. I believe we can all agree on a first point, which concerns routine requests in the everyday life of all public administrations. I mean, laws and regulations in a variety of sectors, possibly going back many years, permit many public bodies to obtain routine information from private individuals other than interested parties. Sometimes make it compulsory to supply this information as a matter of course without even waiting for a request. This is sometimes acceptable for reasons of efficiency, transparency, administrative control of public expenditures, etc. Whether this acquisition occurs online or offline should be, in my point of view, irrelevant to the issue of principle. However, when permanent electronic links are used to facilitate such access, this poses problems that need to be addressed seriously. Identification, legitimacy, selection of methods to be used for making requests, push or pull searches, individual or group requests, audit trails, traceability, just to make some examples. Some data protection acts try to foster for a sort of a comprehensive rather than a fragmented approach. For example, through framework agreements which lay down security measures and guarantees to ensure that data are both relevant and secure, and which can be sometimes evaluated in advance by the watchdogs concerned. But unfortunately, even these safeguards appear not to be longer sufficient. The phenomenon of information misuse is on the increase everywhere. and not penetrated by the public bodies as such, but with the connivance of people operating in them who are entitled to access the data and who pass the same data to unauthorized parties for illicit purposes. For example, to build up files that are increasingly being used to create compromising profiles of the people concerned. Although some information included in these profiles could be accurate and innocent, they are used unfairly in political, journalistic, and economic circles. In particular, in Europe, we see every day private investigators, shadowy figures in the political underground, journalists, politicians that illicitly acquire large amount of information which, when viewed in isolation, appear to be of a little value, but when combined, as I said, with other information from different sources, create a profile that is highly prejudicial to the people concerned. Profiles which neither the police nor the judicial authorities can quickly and easily create. So this is, again, a serious phenomenon that we must not ignore. But there are others. For instance, it has to be mentioned that according to some reports in the press, certain governments have made substantial cash purchases of large private databases from other countries, with a view to using them again just in case. Then there is the even more sensitive question of disproportionate access to private databases, allegedly on police business or for intelligence purposes. On this latter aspect, I would like to highlight a sort of a clear contradiction. On one hand, in parallel with the development of new technologies and ways of penetrating databases, some international courts, some supreme judgments, at least in certain countries, are codifying, I would say, lofty principles to defend habeas data or the right to self-determination in the field of information, or to ensure that a person's virtual privacy cannot be compromised. At the same time, however, advances in information technology have meant that creating permanent and direct access channels to private databases is regarded as a sort of a normal occurrence. So, try to go to the end. I would like to encourage a debate today and see first how is it that these issues are only commonly discussed within elite groups of experts like us, and that no broad public awareness is developing, except perhaps certain spasmodically reactions when a scandal surfaces. To what extent could these problems be resolved more effectively on a political level, on a cultural level, if they were to be debated publicly? And how effective in dealing with these problems are those who instead recommend just best practices or reasonable approaches in the field of personal data protection or data security, but only on a technical, legal, or sectoral level? I think I spoke too much. It's now time to give the scepter of the comment to my good friend Fred Kate, but I would like first to introduce our distinguished panelists. Unfortunately, I regret not to introduce Jacob Perry, which for fully justified family reason is unable to join this panel. We will consider the argument of intelligent databases in any case. And without any priority or hierarchy, I will start with Fred Cake. Make this exercise very simple because their biography is self-evident. Fred Cake, apart from being, I would say, a well-known stakeholder and a friend of all of us, is a distinguished professor at the Indiana University. He's a director or co-director of more than one center of research. He's a senior policy advisor. He's an editor or a founder editor of many, I would say, press journal or review. What else, Fred?
I think that's fine, Giovanni.
Thanks for that. I will give you later the invoice.
Yes, thank you.
Gus Hossain was, I would say, already introduced. Gus, without any prejudice to Simon Davis, is Privacy International. And apart from that, he should be also mentioned as visiting senior fellow at the London School of Economics. He's an advisor of many international organizations and is coordinating many interesting research projects. Nicole Wong is Vice President and well-known Deputy General Counsel at Google. As it was mentioned this morning, she's primarily responsible for the company's products and regulatory matters, including data protection. And finally, John Croft, appreciated Deputy Chief Privacy Officer at the U.S. Department of Homeland Security. Has a long experience, not only as attorney, but also, I would say, in many different activities of federal service. He is also a strategic advisor for the department's international privacy work, and he's present in any interesting event. So, the tool of the office.
Thank you very much. You can keep the microphone. We'll certainly come back to you, Giovanni. Welcome to all of you for being here. And let me add the comment. I spoke with Mr. Perry this morning, who was quite sorry not to be here with us, he as the former head of Shin Bet. So we have promised to represent the views of all the national intelligence authorities here today, which made him especially sorry not to be here to guard against that. John, why don't we start with you? So you've got extensive experience in government, so why don't you give us just a little bit of an insight into why governments collect data and how they now go about doing this in broad terms through the private sector.
Thank you very much, Fred, and good afternoon to everybody. I would like to begin by saying to everyone that if you see me with a lot of papers up here, it's simply because Fred has come up with a list of questions that is very extensive and thorough. So Fred being a professor and me being a sort of former law student, I feel as if I'm under an exam at this moment, and I want to make sure that I answer all the questions to the best of my ability. So I'll be shuffling papers as we do this. What I'd like to do is really give you sort of two parts. I'd like to give some context, number one, and number two, I'd like to then offer the perspective of a government privacy practitioner, particularly from the perspective of a chief privacy office in a federal government agency. And I hope you don't mind, Fred, I am going to step back a little bit, and I'd like to do a little more scene setting, which is to say, when I started to think about this assignment to speak in Jerusalem, I started to look for context, and I started to look for examples. And Homeland Security definitely has a mission in the area of access to private sector databases for legitimate and lawful purposes. But when you open the lens wider, I started to see examples that were global, picking up on what Giovanni said. I looked at examples. The OECD had published a report showing that virtually every OECD member, their banks grant access to their tax authorities for banking information. In the U.S., our government authorities have access to health information, education information. Of course, there's PNR information, which many of you are familiar with. I also noted, even at the state level, there are cases where state tax authorities would like access to, there was a case involving Amazon. They wanted access to Amazon records to determine tax liability. And in the EU, I noticed, for example, VAT tax refunds. It's a way to recover the tax if you're buying duty-free. There's access to airline PNR information. For immigration purposes or Schengen purposes, there's law enforcement access to hotel information. There are many examples the globe over. So I started to just stop with looking for examples. It became, it went on and on. But I think it's worth setting that scene to see that there's an entire spectrum here, from services and benefits to public safety and security. So that's also a way of saying that I can certainly speak for the mission of my department, but I can't speak for the entire U.S. government or the entire set of government authorities around the world. But and now really to the second part of what I wanted to speak about, which is the actual practice for what it is that a chief privacy officer does in the context of government access to public sector databases. And this is a particularly sensitive question. We start really with the premise that that the mission of the department is really based on building trust with the public. And how is that trust constructed? That trust is constructed through providing as much transparency and accountability as possible. And we've taken 2 steps to provide that transparency. And number 1 is by law, we engage in privacy impact assessments, which are a compliance document that requires we review any request for collection of personal information from a private sector database. It must go through a rigorous analysis, and that analysis follows the Fair Information Practice principles. And the starting point for that is there a legal authority to carry out the particular mission for that collection of information? As a privacy officer, I am not a cheerleader for any of these programs. I am first and foremost looking to make sure that personal information that is collected and handled by the department is used in a lawful way. And I think that privacy officers throughout the federal government start the same way. They start under this lawful requirement that we engage in a privacy impact assessment, and that privacy impact assessment is made public. We make sure that that the public has notice of how that information is collected, for what purpose, how it's maintained, and how it's safeguarded. It tracks the FIPS. In addition to the privacy impact assessment, we have also made sure that we have input from outside groups, from the public, to follow best practices. And we, in fact, have an advisory committee that is made up of outside experts from industry, from the academic world, and we have twice asked for their advice on how is the best way, what is the most privacy-sensitive way to collect and use this information. We have 2 reports from our advisory committee, which are public. They're online. In fact, they're part of the public materials here. If you go to the website, you'll be able to access them. But the key that we really do push as privacy officers is to be as transparent as possible. That's the front end, and then the back end is to be accountable, to make sure that all these collections have an accountability element to them, that there is an ability to audit and oversee and provide fairness for the individuals. And the back end would include also redress, an opportunity to seek access and redress if an individual believes there's improper use of their information. So I'm gonna stop there if that's okay, and pass the microphone back to Fred.
Well done, thank you very much. And now, Nicole, from the other side, Google took the, seems to my mind, fairly unprecedented step, a year ago, of making public the number of requests that it receives from government agencies. And I'm just interested if you could talk a little bit about the nature of those requests and how you will deal with those.
Sure, and there's someone at the back of the room, and if you could flip the switch that calls it up. He was paying such close attention earlier. So thank you, everyone, for having us here. I'm looking out in the crowd and recognizing so many faces, which tells me that I'm in what I usually call the double black diamond crowd, which means like the really expert skiers, which when I was somewhat more junior of a lawyer used to intimidate the heck out of me, and now I'm like, oh, thank goodness there's someone else out there who knows more than I do, so we can rely on you. As Fred was saying, and I think what you were talking a little bit about, Giovanni, is public awareness, and how do we make the public more aware about government activity on the internet in particular, because that's my company's job. One of the things we have been talking about for years, and just this year started to do, is to report publicly the number of government requests we see. And so what we did was we created, using our Google Maps API, a really great map of the world, and then we collected from my teams who do both content removals as well as responses to law enforcement requests, the number of requests that we see around the globe. So let me give you a little bit of insight into this map. First of all, it is not complete, and we know it. This is only Google's view of the world, right? Only our services. There are many services out there. There are many ISPs, and my experience tells me that the types of requests ISPs get are probably more than what we see, because at the ISP level, you can capture things in their entirety as they go into a country. You can surveil in the entirety as opposed to just through one service. So again, it is incomplete data. It is also incomplete data because there are some things that, frankly, I have a group of non-lawyers who process these. We build our processes not to report this data, but to process it. So the record keeping that we do simply didn't allow us to get to the type of granularity that I hope we'll be at in a year. But we've done our best so far. So that's the background to what this is. And there's a number of things that we're hoping comes out of it. I actually just spoke at a conference at Stanford a couple weeks ago with a bunch of researchers who are looking at freedom of expression on the web and privacy issues on the web. And the thing that I did was implore them to use our data, to use it as a starting point for seeing anomalies, seeing strange spikes of requests, and then dive deeper. Because as a company, what we can't do usually is tell you, why is it that Brazil, for the second time of our reporting, is at the top of the list in terms of the number of removals that they request? We suggest for the first time in the last report that we did, Libya has suddenly, we had never heard from them before, and this year we heard from them multiple times to make removal bans. As a company, we don't actually have the ability to know the politics going on in that country, the cultural issues going on in that country, to be able to figure that out. And we would love to see more research done in this area. Having said that, so what you see is each one of those little red markers can click open and show you the detail for that country. So I clicked Israel since we're here. It seemed relevant. The 30 data requests means that in the last 6 months, or actually we just reported it, it's the first 6 months of the year, so January to July. We got 30 requests from Israel for user data. It does not reflect compliance, and again, this is a failure of my process in terms of reporting compliance. One of the things is we may or may not comply with any one of those requests. It'll depend on what we're looking at. We may partially comply. For example, it may ask for everything about an account. We'll determine, actually, the level of process you gave us does not entitle you to communications. You might be entitled to basic subscriber information. And again, this report doesn't reflect that yet. It also, and this is a little less relevant for this crowd, it also reflects the number of takedown requests we've gotten from governments. So you'll see here it says we got 4 requests to remove content. All of them came out of web search for the ones that were in Israel. 3 of them were court orders. The total number of things, because any one request might have, sometimes I'll get a request, please take down this video on YouTube. Sometimes I'll get a request that says, please take down these 600 URLs out of web search. So we just this past report started totaling the actual number of items requested. And so those 4 requests resulted in 10 items removed. So that's basically what this is. And I think that the purpose of it is, there's sometimes a debate in the US about, like, can you believe Homeland Security is doing this, right? Or in any one of these countries. And our purpose in doing this visualization is to say the level of government activity is global. It is not just China, it is not just the US, it is not just any one country. They are all doing it. They're all doing it under different judicial regimes. And if we are really going to take seriously the notion of trying to regulate a government, a global platform, then we must recognize it as global and figure out how you can create a system that permits that platform to flourish and yet still be in compliance with all the laws.
Can I just ask one follow-up question? When you get these requests, do you evaluate them in terms of, do they comply with that nation's law? Do you have some other set of standards or privacy principles? I mean, what is the nature of your internal evaluation?
So as an initial matter, it must always be valid, written, legal process. It has to identify the statute upon which it relies. As I was saying, I have a team that is trained to look at it for both form and substance. So in other words, did the clerk stamp it as they were supposed to? Does it have the signature of the person issuing it? But also substantively, they will, to the best of their ability, and I'll be candid, very often they can't know what's too broad. They can have suspicions and then call and ask back, like, this looks like a really broad request. But for the most part, they'll be looking for what is the nature of the request, and does it make sense that they've asked for this type of information. There's an attorney that oversees that team and does the escalations. Let me just complete the process. Sure. When possible, we provide notice to users. It is our policy to try and provide notice to the users so that they have an opportunity to object. And I say when possible because in some cases the law prohibits us from providing that notice. In some cases, the requesting law enforcement official will tell us that it would impede his investigation, his or her investigation, or otherwise endanger it. In other words, if I'm chasing a kidnapper and you go notify the kidnapper, that's not going to work so well. So, and that's understandable. So we will do that. And then we review them. We may ask them to narrow it. We may reject it outright or challenge it in court. Some people may remember back in 2005, the U.S. Department of Justice came and issued us a civil subpoena for all of our search queries in a 2-month period, as well as the entire index of URLs, which for me was like, they said, and could you download that to a CD? And I said, do you have a data center? The search index is large. We were fine with providing a certain number of URLs, but we fought them on the search queries. And they were queries not attached to an IP. They were just the queries. So there are times where we will simply take it to court and we'll fight. And that was one of them.
Great, thank you. All right, Gus. So I suspect there are privacy issues raised here, and if you want to start taking us into those, that would be a good place to start.
Oh, there's nothing to talk about.
Well, that's easy then.
I got to commend the first two speakers so far on the panel discussion, because one of the things that John did very well, without perhaps you noticing it, is that he importantly moved the discussion away from the U.S., because there's so much focus on how bad Homeland Security is, how bad the FBI is, and the silly Patriot Act, and all those stupid things that the Americans have done. But he rightfully pointed to the fact that other countries around the world do this. And Europe is no safe haven when it comes to government access to information. So that was very delicately done. And Nicole, I cannot commend...
I think that was a compliment, John.
Thank you for noticing.
I can't commend Nicole and Google enough for coming forward with this information and raising the level of discussion, and for finally putting government access to information in the right light. Because, so that's the compliment part. The insult part is, despite the fact that your CEO continues to confuse the retention issue, he recently went on CNN and said one of the reasons we have to keep search logs is because of European data retention law. And we've been trying to correct that for the past 3 years. But generally in this domain, Google really has led in such a positive way, so they have to be commended. So, okay, having said all that, let me tell you why people hate us, other than what you've seen this week and the antagonism I've raised for myself this week. We are the unreasonable ones. We are the ones who have to question the fundamentals raised by the first two speakers, that they are unable to question. Fundamental law of government access is if the information's there, it will be accessible to government. That's something that everybody's come to live with. And you have to remember, we fought the SWIFT wars. Well, we actually started the SWIFT wars. We fought the PNR wars. We fought the communications data wars. So we get that the moment the data is there, government wants access. But it's more than that. Once the government has access, it wants to broaden access. What is passed for anti-terrorism purpose is always used for law enforcement purposes. And Europe is particularly guilty on that. Say, for example, when it comes to PNR. PNR, at least in the US frame, is used for anti-terrorism purposes. Europe, they just want to use it for general administration purposes, which is unforgivable. But, okay, having said that. But the reason we're unreasonable on these and say, first of all, the data should not be collected, and second of all, this should not be accessed. We're the only people who say that, is because it's the whole give an inch, they'll take a mile. Data retention is the example. Governments say, well, we have the right of access to this information, so we should make sure it's always available. Fine. You kind of lose the philosophical debate already by saying, okay, it's okay to retain it for long enough that it's actually useful to law enforcement. And then you get the even more pernicious line of reasoning, which is, well, because it was once accessible, because we once had that power, we must always preserve that power regardless of technological change. So what you're seeing in the United Kingdom is the introduction of a regime called Interception Modernization Program, which is essentially requiring every ISP to install deep packet inspection to identify who's talking to who on Facebook, who's friends with who on Facebook, to identify who's talking to who on Skype, and all these other applications. Because the government's argument, which is entirely valid, is if we are able to tell who's talking to who on a mobile phone, because we lost that fight, then why shouldn't we be able to identify who's talking to who on Skype? And because when we were unreasonable in the original wars, and we were told that we were being unreasonable in those original wars, we have no leg to stand on now. Because the general public says, well, that makes sense to me. But that involves creating one of the most expensive surveillance infrastructures we'll ever see. And that's what we're facing in the US right now with what we see as Kalia 2, the revenge of Kalia, which is the requirement that, well, the emerging requirement that, that companies build intercept capability into internet services, which back in 1994, when the law, the Communications Assistance for Law Enforcement Act was created, had specifically excluded information services, internet applications, They now want to expand the jurisdiction. And that's what you're also seeing in India when they say they will get rid of the BlackBerry service unless they adhere to government requests, because the Indians rightfully say, we can listen to the communications on other mobile platforms. Why can't we listen to the information on or read the emails on the BlackBerry? And that's exactly what's happening in Saudi Arabia with BlackBerry. That's what's happening in the UAE with BlackBerry. And it's going to happen across Europe because we are being far too reasonable. We say that just because a power existed before, which we unfortunately said, yes, it's okay to have that power, that power must exist across all technological infrastructures.
Giovanni, I gather you want to jump in. Please do.
Fred, may I try, with your permission? The discussion is already enough salted and sexy. Just to add, I would say, a few pepper. No, just to underline that the more we regard to massive, not to the routine we say, massive government access to databases as a normal occurrence, the more we are consequently superficial in dealing with the purpose limitation principle. Any law enforcement body, I'm now speaking as a judge and not as a protector, data protection protector, is inclined to say, I'm working under the principle of legality and transparency, so my purpose is evidently compatible, fully compatible with the original purpose of the collection. But this is not exactly the case, with particular regard to extensive and unexpected uses. And this is also relevant for a sufficient level of notice to data subjects, because when I provide data to an insurance company, to a bank, to an airline company, I do not expect, I might expect an occasional collection of data, but if we are in front of a massive collection, this is completely different. So we are speaking about public awareness, but we should also consider the individual awareness of the single data subject. Let me make you just an example. All of us, we know that there is a convention, international convention, ratified also by the United States, Japan, Canada, dealing with computer crimes. There is one provision in this convention which allows any law enforcement body of all contracting parties to perform the same investigation activities in another country, just respecting the local rules. It means that if in Japan there is a rule on collection of data in the insurance area, the same could be performed by any other contracting party. And I think that data subjects are not fully informed. So I think we should also evaluate again this problem of massive access. And I would be delighted to see, before I go into pension after 20 years of data protection experience, this morning we spoke about new principles, accountability, privacy by design. Everything is welcome. But I would appreciate that we also apply to this area a principle that I would like to define as a one-box-only principle, in the sense that apart from common information like name, surname, and I think that it's clear to us that there are certain categories of information which are, after being accessed by public institutions and bodies, they are copied, because one of the problems that law enforcement bodies have is a sort of a jealousy. Everybody would like to have in his computer their own data, which have therefore problems of updating, repetition, overlappings, and so on. Why not encourage also, I would say, under the data protection approach, a principle under which, as a matter of principle, any category, any principal category of data should be only stored in a place and eventually accessed online, not on a massive way, but I would say fully justified case by case, with a full traceability in two different places, not only, I would say, at the law enforcement body point, but also at the private sector point, with a view also to prevent another phenomenon which is unfortunately growing in Europe, unlawful acts by system administrators who delete traces of unlawful access to this database. So if we work in this direction, perhaps we could also solve the problem of intelligent agencies, because sometimes they have problems in not discovering, at least in the first stage, access to certain data. This could be justified, provided that we ensure a transparency, at least in a later stage, and so a full, I would say, a full traceability, which could be further verified.
I would like to ask all the panelists, although you may wisely wish to just duck the question, in which I'll start being more specific. It seems like there's an emerging sort of question in the debate over access, government access to private sector data, divided maybe into two camps. And so one camp is the let's manage the process. So we would have transparency, we'll have accountability, we'll have appropriate notice, we'll have education, but at the end of the day, the government's going to get access to anything it wants as long as it complies with lawful process. And the other camp would say there just should be some things which we say the government just doesn't get, or only gets in truly extraordinary cases, not routine access to that data. Is there any room left for that last camp, or are we entirely now all in the let's just manage the process? Please.
I could start off. It may be answering a question with a question, and I hate to do that, but I am thinking on these two levels. One is the philosophical level, which is going back to the different examples that I ticked off when I started my presentation. There seems to be a trend that if governments are passing more laws to, through their democratic process, to collect this information, and as we expect more services and benefits and public safety and security from the government, this trend is increasing. I'll throw out one more figure, which is the public sector of the OECD countries account for 25% of economic activity, and that activity is driven by providing tax benefits and services and processing other e-government and e-health initiatives. So this trend is growing for more access. So as embedded privacy professionals, we're always looking for, well, how is the best way to implement the fair information practice principles to provide that transparency and notice? But again, I'm not truly answering your question, but I think what we do is we provide that transparency and accountability, given that the democratic process has said, you government are going to collect this information. So
let me just add, I'm good, but I don't want to put words in your mouth, so stop me if I'm doing that, but effectively I hear you saying, look, if Congress or if a national legislature in another country wants to say no access to this data, that's its responsibility. Until it says that, it's the job of the privacy professional to manage the process.
Well, part of that depends on the authorities of that privacy professional. If that privacy professional is empowered to, they can correct a program, they can shut down a program if it meets certain standards of the privacy law. But the bigger question is really, if you're going to pass laws to collect this information, that's a fundamental issue. I think if there are certain limits that you want to put on what's taboo, I think you're looking to a democratic process also. That's part of it.
Okay, Gus?
And I'm not a political theorist or a legal theorist, but let me pretend I am one for a second. The UN Special Rapporteur on Terrorism and Human Rights last year wrote a report on privacy in the war on terror. And his primary conclusion was, yes, governments should have access. Governments may have access. Governments may intervene in the private lives of individuals around the world. But all of this must be done within the human rights framework. within the framework of the European Convention of Human Rights, within the framework of the Constitution of the United States, although that's not really as holistic a framework as, say, the ECHR is, or within the frameworks around the world, or particularly within the international frameworks of human rights. And that says, in a just society, governments may intervene, may interfere, but they take on added responsibility. So yes, in theory, your answer is right. But let me put my hat on as PI, which is we fight the political fight. We deal in the real world. And in the real world, in the way that real political discussions take place, you need the extreme to be introduced. Because you know full well, governments aren't going to come along and say, we need this power because of the philosophy of law enforcement needs to maintain a just and civil society. No, they're going to say, we need this power because there are terrorists trying to kill you. We need this power because pedophiles are after your kids. So we need to also come in and say, no, it is not acceptable to have this power. Never should it be acceptable to have this power. And then what eventually happens, and you're going to think I'm going to say things move to the middle ground. That's not at all what actually happens. What ends up happening, the most successful ones of these fights, is that because the two polar opposites are seen, the debate is actually richer. And the debate may fall whichever way the debate may fall, but at least they're richer. And this is again where I have to fault many countries outside of the U.S. Because within the U.S., it's not just Congress passing laws and John's wonderful office doing their wonderful work. It is the work of EFF, ILITA. It's the work of the ACLU. It's the work of all these people who are often considered radicals who present that extreme. In most of the other countries we work with, we work in, or we have relations in, that extreme doesn't exist. So immediately the debate becomes this philosophical debate about how governments must have access for a just society and all of that. And that nothing, and so that worse laws get passed there. And as was said before, those laws then spread around the world.
So,
Please.
and I wasn't quite sure I understood your question, which was, like, if Congress says the government can have a bunch of information for terrorist purposes, and then it all goes into a big pot, and then John's job is to manage who gets access to it. That, I think, is probably not the right outcome. But it's also not, they never get it, right? It is, to me, the current debate, and I'm going to be really American-centric for a moment, so let me apologize. The current debate for us is what should be required of any entity, government or not, before they get access. And so one of the things we've been working on this year with a number of other companies and civil rights organizations is, like, the warrant standard should be applied to more than just contents of communications that have been in storage for 180 days or less. It should be all storage, all content in storage, and maybe even more than that, right? And somebody should define when location information is available and under what standard. So I think there are reforms to be made that are real, and they get to the political debate that you're talking about. I think we need to have more of those debates, not just in political forums, but in courts, right? So thank God for EFF and ACLU to bring those cases into a court and say, we don't know where that piece of data falls. Let's have a discussion about that. And maybe the court will decide rightly or wrongly, but at least in the American process, you get a real public policy discussion going about what is that data, a factual determination about it, and then really something to hang your hat on.
Fred, could I put something out for discussion? And it goes back to transparency. We repeat transparency so much, it's almost like a mantra at the conference, and it's the critical concept for what we do. But maybe a question more for Gus and others, but the transparency is to inform the public. It is to inform everyone how this information is used. And what I'd like to ask for discussion is that transparency used and leveraged the way it should be if people are being informed? Are they reading, are they informing themselves and finding out how the information is being used and managed? And if so, does that make a difference?
The point I tried to raise a couple of days ago was transparency is important and transparency is good. But we also have to remember that before the transparency, issue even comes up, there is still that fundamental right. So we have to make sure that fundamental right's respected. And so let's use some of the examples. Well, let's refer to your office and the transparency field, because your office has done a very good job, say with PIAs, in being transparent. I don't like all your PIs, but you're at least doing PIAs, which I wish other governments would pursue. But I can't say that, for example, the automated targeting system was an example of, I'm not entirely sure you knew what was going on with ATS, and you were as forthcoming about ATS when it first came up, because Customs and Border Police were actually using it without awareness, as far as I could tell. And so even then, even after you explain it, do we still understand the fact that people's information was being processed without any legal basis? And so we had to go back again. Before you worry about the transparency and the reporting you did on it subsequently, there was still processing taking place without a legal basis, and the right to privacy was not being respected. It's not a question, but more of a counter statement.
Well,
Feel free if you wish to
I
respond.
react. I'm happy to react. I'm not going to. I feel like it would be narrowing everything to get into a specific case, but I would say that that particular system got more public comment than any other system we've had, and I looked at that as transparency is working in that case where people are paying attention. So I'll just leave it at that.
But let me ask the sort of hard question, which I think we frankly too often avoid in this debate, which is, what good is transparency? In other words, if at the end of the day you're saying, I don't mean you, I mean the government's collecting data, are saying you have no rights here. We can collect the data, we can use the data, you can't say no. So whether it's my passport being photocopied in an Italian hotel, or whether it's my laptop being copied at a US or a British border post, I can get all the transparency in the world. You can tell me all about my lack of privacy, but at the end of the day, I don't have any privacy. So are we arguing there that transparency actually still serves some valuable privacy role?
You basically better put my point than I did. So that's
The way I was thinking of it is, if people are learning something that they're not happy with, do they take that knowledge, that information, and go to their lawmakers and say, change this law?
Okay, so again, I'm just trying to be clear, and I think you raise an incredibly important point, which is, it is at least one step completely different from secret surveillance. So that if there's transparency, at least it's possible for the political process to work on it.
There's an opportunity for political debate. That's what I see transparency
Okay,
doing.
Giovanni's been waiting very patiently.
No, time to abuse of my role of chair and put a question to the moderator.
And I should have let you continue to wait, yes.
Imagine to be back, I would say, at the Indiana University and to be in front of your students and try to explain your vision on how to deal with this phenomenon in, I would say, in a modern democracy, I would say out of emergencies and in normal circumstances, because this is also something relevant in terms of economic costs for citizens, and who pay for that, users, citizens, and so on. What's your vision on that? Thank you for answering.
Yes, thank you. Thank you very much. I'm so glad we invited you. Let me say, first of all, I actually continue to think, and I think this is a political question, and I think ultimately it really needs to be a political question as opposed to a judicial things. But because we just aren't willing to do that. We draw a line there. We don't let utilitarianism determine that for us. And I think we can think of examples again and again and again where you can think of relevant data where we just say, we're just going to deny you access to that absent some extraordinary process or some extraordinary circumstance. So the issue which I worry most about is this notion of giving that up, so that we say at the end of the day, there's nothing you can't have. Because it's all going to be captured digitally somewhere. So we won't go to you for the data, we'll go to Google for the data because they're going to have it, or we'll go to another company. And so I think it's still valuable, although I may also be, along with Gus in this sense, not in a practical world. but to continue to think about places where we would say, we're just drawing a line here and saying no. You know, even though the data might be very relevant, we're not going to allow you to have that. And I think we still do that to a certain extent in law. So, for example, we don't routinely allow blood tests at borders. It would be highly relevant. We'd learn all sorts. We'd get DNA information. We'd have all sorts. But as a rule, I suspect almost all national courts, including the U.S. Supreme Court, would say no. That violates human rights to say we're going to have a blood draw on everyone. I think the problem we've had is where technology is involved, many of our both policymakers and judicial decision makers have had a harder time analogizing that. So they say, well, we'll take all your data, but we're not going to take your blood. At the end of the day, taking all the data might be a bigger privacy invasion in a practical sense. But having said that, I don't want to lose the point that John and others have made, and I think is very important, which is the process is also critical, so that we want officials, whether law enforcement or otherwise, to follow a lawful process. And this, you know, then brings, I think, to the hard issue, which we talked about earlier on a phone call together. What do you do about governments where their legal process appears to be lacking or non-existent? What do you do about totalitarian governments? What do you do about governments that are admittedly going to use the data for anti-human rights purposes? But they say, look, we followed our legal process, or our legal process is we don't have any legal process. Do we then say, well, at least you followed your process, we're comfortable as data protection officials, you go ahead and get the data? Yeah.
Is that supposed to be, is that a company question?
I was going to see if someone would fall for it, but...
I will be the avatar for companies. So I think it's a couple things. One, from our perspective, part of what we do when we decide to enter to do business in a country is an assessment of that country in terms of its human rights laws, its privacy and freedom of expression laws, the existence of rule of law. Like, one of the things we look at is the court system reliable? Is the level of corruption, which the Transparency Report, not ours, but that Transparency International, I can't remember the entity that puts it out, does an index of corruption in a country, and it's one of the things we factor in, is like, if we start doing business here, is this an okay, if we have an issue, is there an authority to take it to that is independent and will make a rational decision? So I think there's, prior to ever getting a piece of paper, there's this one question of, am I doing business there? And then there's separately a question of, and this is a little bit of Google's experience in China, I'm going to choose which products I offer there. In China, we never offered Gmail, we never offered Blogger, we never offered any of the services which we felt could be subject to a government request where we might put a political dissident in danger. And those are choices that a company has to make. So I think that is a portion of it. For the last, I can't remember now, it's been like 4 years, I think, we've been working with Yahoo and Microsoft and a number of human rights organizations and academics and in an effort called the Global Network Initiative. And that is a group of companies and human rights organizations who came to some agreement on certain principles around freedom of expression and privacy that we would adhere to as a group, which has been hugely helpful, not only because we all share a lot of information, like, hey, did you see that thing happen in Vietnam? What are you planning on doing about it? But also because we're unified, because before that happened, sometimes what would happen is, like, I'd get a call from a government official saying, the guy down the street, he gave me that stuff, so don't tell me you can't give it to me, right? And that all of a sudden puts me in this place where, like, well, I'm telling you I can't give it to you. When the countries are unified on that, it puts a lot more pressure on that government to sort of be upfront about their level of authority and not do the backdoor pressure that some governments will do.
Yes?
And, you know, I'm not often the type who takes responsibility off companies for privacy invasions, but in this case, let me do this for a second. It's our fault, our collective faults, people in this room, as to why bad countries are able to spy on their citizens. You know, when it was discovered, the Wall Street Journal discovered that Nokia Siemens was involved in Iran, and that was used, and backdoors were used to spy on the opposition. Everybody, including the European Parliament, got terribly angry at Nokia Siemens. And whenever we did media on it, the media hated us because we kept on saying it's not Nokia Siemens' fault. It's Bill Clinton's fault. It's the European Union's fault, because the mandating of backdoors into the technologies began in the 1990s in the United States, and that was then transferred to standards institutes in Europe. And so now every telecommunications kit built anywhere around the world has these backdoors built in, so it's no surprise that when the Iranian government buys the technology, it has these backdoors in there, all to standard spec as set by the European Telecommunications Standards Institute. But nobody wants to hear that reason. They want to be able to blame a company and say, this company's bad. When in reality, it's these people we hold up as these wonderful democratic institutions who were defending the rights of a civil society to exist, to make sure that terrorists and pedophiles couldn't do things. They're the ones who are at fault for these.
Giovanni?
No, just an additional comment. I think one of the elements of the possible guideline in this area is the, may I call that, predictability. I would say we spoke about costs, economic costs for citizens, but this activity is also costly for private entities, at least in terms of human resources. Any private impact assessment should also deal with, I would say, an expectation of a massive access. So perhaps we should also consider the categories of public bodies involved. Any police organization, any judicial authority, and mainly any intelligence service, works in a perspective, in a NIMBY perspective, to say data protection is something for others. So it's time to not to consider all these three categories of public bodies fully equal to any other public body, but in any case to consider that this problem should be, I would say, evaluated in the next future in a different perspective. Europe is working hardly in this perspective. I make just one reference to an article, Article 16 of the new Treaty of the European on the functioning of the European Union, which now provides for a comprehensive framework. So, in principle, no distinction between the former first and third pillars issues. Obviously, adjustments are possible in terms of notice, for instance, or I would say specific derogations, but I would say with a tendency to have, I would say, a unique framework under which we deal in time, in a modern democracy, with such a need to have access to this data. So Europe is going to replace the framework decision 977, which now only deals with the exchange of data, which is an unworkable instrument because it only deals with data which are to be considered to be transmitted. You can imagine any policeman distinguishing any day these data are for domestic use. This is not the case. So we welcome this approach. Next week is a crucial, I would say, step, and we are confident that the Commission will submit to the Parliament and will submit to the DPS for his opinion a good, I would say, basis of discussion with a view to deal especially to this issue. Not speaking about the destiny of certain databases which are relevant also for the international dialogue. So one of the points which was, I would say, considered by the DPS in the recent past was also the relationship between incoming or possible international agreements, like the one I already mentioned with the US, and this new legal framework. So any new legal framework should be an umbrella, a comprehensive umbrella to cover and not to be, I would say, the day after simply derogated.
Thank you. Now, we had agreed to try to leave a few minutes for questions from the audience, and I've almost failed in this regard, but we're going to just try to get as many as we can. If you'll just state your question, I'll repeat it into the microphone. Yes, please.
So Gus has tried twice already to talk about ILITA. I frankly don't want to talk about ILITA because I bet most people haven't formed opinions yet. Oh, there's a microphone.
Oh, you get your own microphone now.
I'll be here all week. So I want to know about the appropriate relationship between the government need for data and company decisions about architecture in the absence of law. And so I think I direct this initially at Nicole, but I'd love to hear what Gus and John have to say as well. So Nicole, at Google, how often do these topics come up? One, should we structure the architecture of X application to facilitate what we know the government will want? Two, should we intentionally make it harder to facilitate the access the government wants? Three, should we just not go there, for example, and not do a service that has location information of everybody at every time of day because we know it will enable the government? Do any of those three conversations factor in? And for the other two, should they?
Okay, so I'm not sure I'm going to cover all three of yours, but I'm going to try. So I think I'm going to start with three, which is, do we consider it at all? And so let me start with, the first consideration is the user, right? So the first consideration in the design of any product is this useful for the user, and that's why we're doing it, because no one will use it if we build it for the government, right? That's not our audience. We've got to build it for the user. So it starts with that. In terms of, do we build it to be easier or harder for the government? I'll give you two examples that we built it harder purposefully because we felt we were really committed to the privacy aspects of it, and for which I get a lot of grief from governments on an almost weekly basis. The two things are this. One is in Gmail, all email has a header. Most of the time, for most webmail services, that header includes the IP address of where the email originated. Our engineers looked at that and said, we don't need that, so we're not going to keep it. What that means is that the person who receives the email, or if that email is collected by law enforcement, when they open up a header, they don't find where did it originate, and that really frustrates them. And we're not going to change that because we don't actually have a need for that piece of data. So that exists. The other one is Gtalk, which is the chat function that we have within Gmail. And it was built so that you could take it off the record, so that you can have a chat with your friend, and when it can be on the record, meaning that your chat can be saved as an email in your Gmail box, or you can go off the record, and you can choose to default always to off the record, in which case nothing is saved and Google never has it. It's a peer-to-peer connection, so we just don't have it. That too, for governments, I can't even tell you how many times I've been asked, can't you build that to tap it? It was not built to tap. It wasn't. And that's frustrating for some governments. And we probably are going to have, particularly in light of some of the legislation that's going to come up, we're going to have a real serious conversation about whether we will be required to.
Gus?
So Privacy International spent the past few years trying to get back in contact with the people who build the technologies. After 9/11, you can imagine we spend all of our time just trying to talk to policymakers, and we realize how useless that was. So we got to go back to the people who are building the technology. So speaking anonymously about the conversations we've had some very heartening conversations with developers. But I think I think the ethics of the engineer who's building systems today is not as strong as it once was. I'm not saying they're acting unethically, it's just they have a broader mind. There's a few engineers in a number of companies we've spoken to who when we asked about things like Tor, they had to admit that they've seen some ugly things out there, and it made them feel uncomfortable. And you know what? Any human being would react that way, and that's completely understandable. But I guess what I'm trying to say is what's different now than what's different before, perhaps in the ethics of the engineers. In the 1990s, crypto was cool. Crypto, being a cypherpunk was really cool. And a lot of these people were the people building the core systems that we use today. And that's why we had all this discussion about security technologies, privacy-enhancing technologies. And that all died off very quickly in the 2000s. And I know a number of people have been trying to re-enliven that discussion. We've had some of the speakers of this conference being part of them, and Casper Barron at the front being one of the great people for bringing people together on this issue. But what I'm seeing when I talk to the younger engineers and what we need to fix is the idea of social is cool. The ability for individuals to share is cool. We should design our technologies in that distributed way. Whereas in the 1990s, when we designed technology in a distributed manner, it was because we didn't want a single point of failure. Now we want to be able to allow people to share across distributed points. And that worries me, because you almost don't need a government mandate in order to make it vulnerable. We now are designing vulnerability.
Okay, other questions? Casper, yes. Thank you.
Casper Bowden. I'm not actually speaking now as Microsoft. I wanted to make some remarks because I'm actually a member as an independent expert of the European Commission committee implementing the Data Retention Directive. And I just wanted to say a few remarks specifically about the Data Retention Directive in the context of the European Convention of Human Rights. But before I do that, Signor Buttarelli just made a remark about the possibility of establishing some kind of data vault, which would, as it were, be a comprehensive repository of traffic data. I do refer him to some papers that Claudia Diaz, who was speaking earlier today, has analyzed that possibility from a computer science point of view, and a riposte to those papers from George Danizis. And George has demonstrated that that idea of a data repository has fundamental bypass weaknesses, which would actually tend to negate the purposes which you think might be possible. But just to return to the European human rights position, I just want to suggest that there is a methodology which one should adopt to analyze the legitimacy of the European directive, the Data Retention Directive, and this is now currently being reviewed with a view to either replacing, perhaps with a data preservation regime, or leaving as it is, or possibly repealing, or possibly even extending to what Europe calls information society services, such as search engine history, which of course it does not currently apply to. So the idea is this, that under the ECHR tests, one would probably have to say that given the scope, legitimate scope of the Data Retention Directive, the first question you should ask yourself is, can a particular case be solved by less intrusive means? In other words, is there another investigative methodology other than the blanket retention of data on 500 million people which could actually solve a particular case? And so you take out a certain number of cases and subtract those off. And then you ask yourself, well, are all of the remaining cases that national law enforcement bodies are using the Data Retention Directive for, are they all serious crime? And it turns out the directive only authorizes the investigation of serious crime, but probably a lot of member states are actually applying these to less serious kinds of crime. So you subtract out those cases as well. And then you ask yourself, well, the remaining cases, could those have been solved by a data preservation regime? In other words, if there's some response time by law enforcement to identify a suspect, and then you have some almost like a parallel warrant procedure, but at a lower threshold of suspicion, and you say, okay, begin recording data about that guy. And you say, well, under that regime, how many of these cases could we have solved? And by the time you subtract out all those cases, then you're down to a very, very small residuum of cases indeed. And I suggest the correct way then to evaluate the proportionality of data retention as a concept is against that small residuum of cases compared to the public interest. And if one does the proportionality calculation that way, I suggest the case for data retention does not look strong at all. And we ought to go back to considering the feasibility of a dynamic data preservation regime, which will be more burdensome for ISPs. There's no doubt about it. They would have to deal with thousands and thousands of individually targeted requests. But maybe that is technologically feasible, and from a human rights point of view, I suggest that is infinitely preferable.
Thank you very much. All right, we have time for at least one more question. Right here on this side, we'll see, right there. Oh, it's Alan Rawl.
Thank you. There was a mention of, by Gus Hussein, of the value in drawing attention to the data access practices of governments besides the United States. And there's a recurring theme in many of these conferences about the relative adequacy of the U.S. and EU data protection regimes. Is anyone on the panel aware of any analysis of government access rights and practices in the United States and other countries to compare which of the regimes is more protective of privacy and other civil liberties interests?
Anyone aware?
The answer is no, except for my poor work. The Christmas...
Take that as a yes.
No, I'm a very sad person. It was in early December, was it 2005 that the directive was passed, Casper? The retention directive was 05?
November 2005.
Yeah, so it was late November, early December 2005 that they passed the data retention directive. And I got terribly drunk and angry over Christmas and wrote a report basically saying, you know what, let's stop focusing on the U.S., let's start focusing on Europe. Europe should be ashamed of itself. And started to compare the regimes of lawful access within the two blocks. I did the best I could, but the reality is, can you name all the laws in the U.S. that give access to data? There's a number. Can you name all the laws in Europe within any given country that gives access? There's a number there too. So it actually becomes a very difficult exercise, which only accentuates why all this is so crazy. You can't just point to a single law saying this is the law that needs to be fixed.
Yeah, and this goes a little bit to your point, is does transparency help? Because I tried to do this a few years ago in a really discrete area, which is like wiretapping. So, because in the U.S., it's actually required for the Federal Bureau of Investigation to report the number of wiretaps that it does. And it's actually surprisingly low. And I wanted to compare it across jurisdictions, but it's very hard to get apples to apples, right? Because it's a very specific statute that is required for the reporting, and it's not everything. And then in other countries, I'm not even sure exactly which agencies were involved in terms of what I was looking at. When I came up with this like 3 years ago, I think there was something like 1,800 wiretaps reported in the United States over a year, which was a surprise to me because for some reason in my head with the media, I had like tens of thousands in mind, but it was like 1,500. And then like Italy, I think was 100,000 or something like that in the same period. But again, like I'm not exactly sure whether I was comparing apples to apples. I think like if there were an agreed upon mandate among countries to do reporting that is real and consistent so we would know where do we need to focus, that would be helpful.
I'm not familiar about, I would say, in-depth analysis comparing the EU and US situations, at least on a general basis. Perhaps that there are on specific databases. But at least at the European Union side, there are more than one, I would say, survey or professional analysis on different practices at national level with regard to different categories of data. Italy, for instance, coordinated some years ago a well-qualified project, well-known Giovanni Falcone project, comparing, I would say, the different practices with regard not only to traffic data, but to other important sources for investigations. I would like also to mention the work in progress in the data retention group, which is particularly interesting with regard to, I would say, new categories of informations which have not been sufficiently evaluated when the directive was adopted. And the 29 Working Party 2 is investing energies in certain enforcement or pre-enforcement actions comparing different practices. So at least, not mentioning obviously qualified surveys coming from Privacy International and EPIC, obviously.
I'm not aware of any study, but I think it would be a fascinating topic and would invite anyone to do research on it.
Okay, yeah, that was good, and we're going to fund that. Let's just try to get one last question, and can we get the microphone over here? Anyone you can, how about in the back there? We've so favored the front, yes. Well, I think he's even farther behind you, so.
Thank you very much. Peter Michel is my name, and I'm one of the data protection supervisors for Europol, the European Police Office. I'm lacking in this whole discussion probably an essential issue which, according to me, and I have almost 30 years of experience of data protection supervision in law enforcement, it's probably not the access government authorities have to commercial intelligence. It's the use they make of it and the techniques they do. Because, let's be honest, there's no police investigation without getting data from private parties. That has been in the past, it will be in the future. But it's more the techniques of investigations, the scale, and probably more, I'd say, techniques like profiling and fishing for possible criminals and possible facts. That makes the infringement so evident, not the fact that they have the access. And one could discuss whether, if my feeling is true that it's not the access but usage is the problem, and then going to the transparency, that it's transparency and a sort of accountability for law enforcement authority to prove that whatever they did was effective and necessary. And if they can't prove it, then there's a reason to withdraw the competence, either to get the data or either to use their competences in investigation. I think that's very essential in controlling what has been done by law enforcement organizations and private data. Thank you.
Thank you very much. So why don't we quickly run through the panel, starting with you, Gus, if we might, with just a sort of final thought, particularly looking forward. So if you could say, here's something I would like to change, short of eliminating government access to data altogether, what would that be to try to protect privacy while still providing for the responsible use of data?
As you're designing laws, as you're designing technologies, know that your laws and technologies will be used in places that are very dark and that are very dangerous.
Oh, so ominous.
Right. Well, you can cheer us up now.
So I think in the future there are two things that I'm looking at. One is real and focused reform on government surveillance laws. Most of them are 20, 30 years old, and they have to be updated. There's too much happening out there. There's too much ambiguity about how do I categorize this data and what level of process is required for it. We absolutely must update those laws and update them with appropriate government oversight. There are a lot of laws, in the U.S. included, where the request is signed out by a law enforcement official, an officer of the court, with no judicial oversight, and I think that's a mistake for some levels of the types of data that are at play. And the second one is a company thing. I think companies need to step up and agree upon some principles about how they engage with governments on these requests. And it is too easy for a lot of them who don't want to have friction with the governments and where they're doing business to say, yes, here, whatever it is you asked for, I will turn that over. We have to be critical about the requests we get. We have to agree on standards, per my example before. When one guy down the street gives it up, the government thinks that everybody else should too. And so the companies should be working to make sure that we are agreeing upon the same principles and consistent in our responses.
John?
I can, again, go back to the perspective of an embedded chief privacy office and say that the hard part looking forward for us is there are fantastic fair information practice principles out there, but when laws are passed to collect information, the real hard part is implementing those principles in a practical way. And so for us, I think that the challenges are in seeking to improve and strengthen and enhance those privacy principles in practice.
Thank you. Giovanni?
I appreciated the reference to the use of this data because I started in discussing this point with the notion of access, thinking exactly to the possible use. I think that the past experiences on data mining on the German Rastafandung are so evident that at least in Europe there is no space now in the next future for such similar experiences. But coming back to the issue of collection of data, to the jealousy, to the principle that since it is better to connect because this data might be used because I will use this information in the principle of legality. I think it's time to encourage all the data protection authorities first, including my authority, to open the discussion to other stakeholders. Until now, the discussion has been in place on a bilateral level with law enforcement bodies, sometimes to ministries of interior or justice. Business companies sometimes stimulated this debate, but it's time to have a more global approach because, as it was said, this is also relevant for the future architecture of online environment and the architecture. So it is useless to speak about privacy by design and then to think that on a day-by-day basis we should rethink everything.
Thank you very much. Thank you for joining us, and please join me in thanking our panelists and chair.